Court of Appeal and for the 6th District of the State of Florida is now in session. Jonathan Dan Trader, Chief Judge, presiding. All persons having been before the court draw near, give attention, and you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. As the Marshal said so kindly, I'm Dan Traver. I'll be presiding this morning. I'm joined on this panel by the Honorable John Stargell, who is at my right, your left, and the Honorable Petra Brownlee, who is at my left, your right. This proceeding is being streamed live via YouTube. If you've forgotten to silence your cell phones already, you'd do me a kindness if you did. We have one case on the docket this morning. It is case number 23-1909. It's Holding Insurance Companies Accountable LLC, AAO Kevin Sims versus Security First Insurance Company. Mr. Barr, the typical is going to be 5 minutes for rebuttal. Would you like more or less? Whenever you're ready, sir.
Good morning, may it please the court. My name is Chad Barr. I have the pleasure of representing the appellant in this case. I do have to say I'm a little bit disappointed with the amount of attention that the appellate courts have been getting in the national media that we don't have a bigger crowd here today.
We're all watching on YouTube, Mr.
Yes.
Barr.
We're here today asking the court to reverse the trial court's order of dismissal, primarily for two reasons. One, we believe the trial court went beyond the four corners of the complaint and its legal conclusions, and that the trial court misinterpreted and misapplied 627.7152. I do just want to be clear about something from the outset. While we believe it would be easy for this court to reverse on the first point, if this court does agree with us on the first point, we would ask the court to take the next step and also decide the second point as well. Our fear is that if we get a reversal on a procedural issue, that the court could construe this court's ruling as being finding that the trial court's interpretation of 627.7152 is the law of the case. And we do strongly believe both of our points together should result in a reversal of the trial court's order of dismissal in this case.
Is there something in the record, Mr. Barr, that tells us the brief sets out well what your position is that your client's company does not do? Is there something, if it is unlike the companies that provide services or that are repairing property, is there something in this record that tells us what it does? Because there doesn't, if I'm correct, there's nothing attached to the complaint, and then there is no response in opposition to the motion to dismiss, and there's no transcript. So how do we know? Are we just taking this at face value, or is there something in the record that tells us what the company does?
I think that the key is what the company doesn't do. And the allegation, the complaint being that they don't provide those services that are listed in the definition of an assignment agreement is enough to get us past the motion to dismiss stage. So no, there's nothing in there that says specifically, other than they're assigned the benefits for the purpose of litigating the lawsuit. That is in the complaint to prevent the insured from having to go through the burden and hassle and financial consequences of a lawsuit, which, you know, that is a perfectly normal or not, a perfectly acceptable explanation.
Why is that not included in the including but not limited to then?
That is a very specific point that I'm prepared to argue. If I wanted to just get the elephant out of the room with respect to the transcript issue, if you don't have any questions about that, I just want to make sure that we are explaining that the trial court's order on its face sets forth the issues with respect to what our position was, what the issues are in appeal, and what the trial court's ruling was. I
understand that that's what your argument has to be. One thing I always appreciate about your briefing is how seriously you take the presentment requirements below. Everything's always very fleshed out, and I recognize that you aren't lower trial counsel, and that's not what you do. But in this particular instance, you're making some very nuanced statutory interpretation arguments to us, and whether those were made below, we have really no way of knowing. We know that they weren't made in writing. We don't have a transcript. I do want to hear your answer to Judge Stargill's question, because I think it's really important. But just before we move on to the substance, would you please just address presentment and in light not just of the lower court made a statutory interpretation argument in its order, which of course it did, that it analyzed the precise issues that you're raising before us.
I can't go any farther than the court's order, because there is no response, there is no transcript. You know, and I don't have an explanation for why that wasn't done. Thank you for acknowledging that I didn't handle that. But I think the key is that the court made it very clear that what our position was is that 627.7152 doesn't apply because we don't provide those services listed in the definition of an assignment agreement. And the court said, well, that, you know, the whole walks like a duck, talks like a duck, it's a duck analysis, saying, well, it's an assignment agreement under an insurance policy, so therefore 627.7152 applies. So that's all I can offer you. I think that if we look at the case law in our briefing, I think that's enough. I think the error appears on its face where the court is saying 6277152 applies. That is the precise issue, and we feel that it doesn't. So I can't really go beyond that, but I think there's enough there on the face.
Was the assignment attached to the complaint? My understanding is it was not.
It was not.
How did you all expect to survive dismissal just given that?
Well, it wasn't addressed by the court. So
Okay.
We could have filed an amended complaint. It wasn't done.
Did you ask to do that?
No, we didn't ask for that to be done, and we're not asking for that now. Obviously, we can't. But I don't believe that and it wasn't addressed by either side. So, but I believe there's case law that would support the conclusion that we don't have to attach an assignment of benefits to the complaint. So, and that's, I guess, probably a conversation for another day.
What about the failure, though, to ask for leave to amend? I mean, it's the first complaint. The trial court would have given it to you. Again, I know that you weren't the one who
I
did it,
don't-
but does that present your client with some presentment issues in this particular case?
I don't think so, because based on the court's ruling, we weren't going to survive a second bite at the apple anyway. The court said 6277152 applies, and you didn't comply with the statute. So we weren't going to meet the standard. So that's probably why it wasn't requested in the first place. But I don't think it would have helped this position at all.
But couldn't it theoretically have showed the court why the services provided by your client was unlike the laundry list set forth in the statute?
Yeah, and I think we need to look at the case that we cited. Actually, the court disregarded it, but the Sigma case, and in that case, it's exactly like this case. The question was whether or not there was enough there for this court to determine whether the services or the statute applies to the services that were being sought in that case. And the court said there's not enough here to make that determination. So the 5th DCA reversed that ruling. That means the Sigma case couldn't be more dead on point. And actually the questions that you're asking are in direct opposition to what the appellee is saying, because what the appellee is saying is, well, because you didn't provide services related to 6277152, then you couldn't comply with the assignment agreement requirements anyway. So the court didn't have enough information, clearly, if there wasn't an assignment to even be able to tell whether the assignment complied with the statute or not. But even still, looking at Sigma, there's not enough in the complaint. Could we have put more? Yes. Were we required to? No. The court looked at it and said, looks like a duck, talks like a duck. It's a duck, without giving any consideration whatsoever to the fact that our complaint said that the statute doesn't apply because these aren't the services contemplated by the statute.
I stepped on Judge Stargett's question.
Yeah, no problem.
Not limited.
So we have to look at the statute as a whole. All right. And their whole argument is that I think what would be helpful is to have just kind of give you a brief history of 6277152. If you'll indulge me, if you have questions, please interrupt me. So the statute was enacted in 2019. And if we look at the final House analysis for the bill, that was.
Now, when was the amendment that added the including but not limited?
January 2022.
Right.
All right. So 2019, the statute was enacted. The problem that the legislature.
So the Sigma case was decided before the amendment, correct? That was a 2022 case, but it was based on activities that happened before.
Well, I don't know that I agree with that, because the statute has to. I have to go back and look.
Oh, okay.
So 2019, the statute's enacted. The legislature stated in its House analysis that it was trying to combat the issue with respect to contractors, water remediation companies, and other vendors who repair damaged property and who bill the insurance company for work.
You agree that we don't rely on legislative analysis?
No, but it takes us right into what the original definition in 2019 didn't include the limited, including but not limited to language. But the reason why we had the January 22 amendment was because what we had was these engineers were filing lawsuits They weren't hammering, they weren't taking down baseboards, they weren't taking down drive. They were just coming in and doing inspection services to determine where the water was coming
But
from.
you,
So
the statute doesn't say that. You don't know. That might have been the impetus for why the legislature said, oh, wait, we need to look at this and make sure our language covers everything that we want it to cover. And then they passed an amendment that says including but not limited to, which didn't say engineers. If they'd wanted to cover engineers, couldn't they have just added engineering services?
well, that's what I'm getting to. So once the lawsuit started being filed, the legislature amended to include now inspection services. Inspection services weren't in the original statute. So the legislature, when it amended the statute in 2022, was addressing the issue of these engineers filing lawsuits saying, we're not doing services to repair, protect, maintain, mitigate, we're just doing inspection services. And so the legislature amended, and what they were doing when they included the language, including but not limited to, was making it very clear that you cannot argue that you're doing something with respect to the property and it not be within 6277152. So if you're doing inspection and it's somewhat related to repairing the property, then it's
I understand your argument is that it's 100% has to be about the property, but it says services, including but not limited to, and services. And to take your complaint and in its context, you're providing services of accountability, financial protection, and relief from onerous obligations.
And those aren't services directed to the
To the
property.
property.
Those are
That's your
services for
argument.
the homeowner. And so what
But
we,
couldn't the legislature have said specifically only services to the property?
the argument that the appellee is making is that 6277152 applies to any assignment of benefits with respect to a homeowner's insurance claim. If the legislature wanted that to be the case, they would have said that. They would have said, this assignment agreement is any assignment of benefits with respect to a homeowner's insurance claim. And they would not have included the qualifying language of protect, repair, restore, replace. They would have just stopped at an assignment agreement with respect to a homeowner's insurance claim. That's where they would have stopped, but they didn't. They kept that other language in there, the qualifying language, the including but not limited to, if you look at it in a vacuum, appears maybe the appellee has an argument to make, but we can't look at it in a vacuum. We have to look at the whole statute together. And there's really 4 reasons why.
Well, let me ask you before you go into that. Let me just ask you if I accept your position and I look at the 10th paragraph of your client's complaint. And it talks about providing accountability, financial protection. One of the provisions in there, even if we look at it the way that you want to, is talking about protecting the property. Are you basically trying to thread a needle between saying we're providing financial protection to the homeowner, but not to the property, even though the only reason we're here is because of an insurance claim?
It's providing financial protection to the insured, not to the property. So they have nothing to do with the actual property.
But the protection wouldn't be offered, I understand correctly, though, if there wasn't an insurance claim that your client was coming in to help out with.
I think we have to take a step back and look at this and say, all right, what are the risks that an insured faces when they're filing lawsuits? We've got 57105s, we got proposals for settlement, we have fee shifting, we have cost, we have all kinds of things. Those are the financial risks that a person takes when they file a lawsuit. What the appellant does is they shield the insured from those by filing a lawsuit for them. And so that's the financial protection that they're providing. It's nothing with respect to the actual property. So if you look at each one of those words in turn, what they say is inspection of the property, protection of the property, repairing the property, mitigating against further damage to the property. And it's talking about services, including but not limited to that context.
I feel like what you just said is not in the complaint and not in the record. Show me in the complaint in terms of as it relates to providing those litigation services against 57105. It's a thin record.
Yeah, I mean, it is. But when we're talking about the financial protection, I think they've said enough. I don't think that they have to get into the detail, the level of detail that we're talking about right now to explain exactly what they do. The question
But they
is,
have to if there's a statute that governs a different category, right? And so if you're making an argument to a trial judge and saying we are unlike these things, don't you necessarily have to make a showing as to what you are like?
at a summary judgment, yes, but not in a motion to dismiss. Because in the motion to dismiss, the court has to take the allegations as true. So they have to look at the allegations and go, they're saying that they're not, there's nothing, the only time that doesn't work is if there's an attachment to the complaint that contradicts the allegations and then the exhibit controls. There's no exhibit.
Yes, to a point. And let's talk in a vacuum, generally speaking, because we're an ultimate fact pleading state. You know, we're not a notice pleading state. So at some point, there's got to be some sort of detail, right? I know you would of necessity say that that detail was met in the complaint in this particular case. But what can't happen, and I think you have to agree with this, what can happen is that somebody can plead a complaint with no ultimate facts in it and have that be a gateway through to discover.
But that was never an issue, and that wasn't what the trial court ruled on, and it definitely wasn't what they filed in their motion to dismiss. There was never an argument raised in the motion to dismiss either that our pleadings were insufficient. And so what we're left with is the fact that we've got an allegation that we don't fit within 7152. And I just want to say we have to look at the statute as a whole. And there's absolutely no way to construe the statute as a whole and come to the conclusion that it applies to every service potentially provided in the context of an insurance claim, whether it be to a person or to a property. We look at, we talked about the definition, but let's talk about what an assignment agreement has to include. All right. There's no way that if someone is providing a service that's beyond something to the property that they can even comply with the requirement of the assignment agreement. There has to be a right to rescind without penalty that corresponds to a date that commences to work being done on the property. There has to be a written itemized cost estimate of the services to be performed by the assignee. Here's a big one. The assignment agreement relate only to work to be performed by the assignee for services to protect, repair, restore, or replace a dwelling or structure or to mitigate against further damage to such property. So essentially, that requirement alone, anyone who's doing anything other than hammering on the house can never comply with the assignment agreement requirements. If we're looking at this going, it applies to everything.
Maybe that's what the legislature intended.
We have to keep going though.
You're into your rebuttal time too. Just
I appreciate that.
It's up to you.
We also have to look at the requirement of the assignee's duties. The assignee has to maintain records of all services provided, cooperate in the claim investigation, provide requested records and document related to services provided, provide the assignor with an accurate and up-to-date revised estimates of the scope of work to be performed, perform work in accordance with accepted industry standards, not seek payment of deductibles. And then there's the conditions precedent to filing suit. Again, we can't comply with these unless we are actually hammering on the building or doing something with respect to the actual property. Because as a condition precedent, we have to submit to EUOs that are within the scope of the services performed to the property, the repair, restore, replace. We have to submit a pre-suit demand letter, and as a condition to filing suit, we have to provide a detailed written invoice or estimate of services, including itemized information on the equipment, materials, and supplies, the number of labor hours, and in the case of work performed, proof that the work has been performed in accordance with accepted industry standards. Again, unless you're actually doing something to the property, you can't even comply with the conditions precedent. So that leaves us with the unmistakable conclusion. You cannot look at this statute as a whole and find that it applies to anything beyond just services directed to the property. So I'll use the rest of my time for rebuttal. Thank you.
Counsel.
Good morning, may it please the court. My name is Tara McDonald and I represent Security First Insurance Company in this matter. Before I get into my argument, I want to address some of the issues and questions that you all raised to counsel for HICA. One thing we need to clarify as we get into this is some basic concepts. First is, on a motion to dismiss, the court is required to look at the well-pled factual allegations, not the legal conclusions. And I think a lot of the argument that was made, especially in the briefs, was that basically these legal conclusions were set forth in the complaint and that needed to be accepted. And we all know that's not the case, just the factual allegations.
In other words,
Yeah.
because somebody says that we're an assignment of benefits allowable under the statute, the trial judge doesn't have to accept that.
Exactly. That's for the judge to actually look at the facts that are pled and the arguments that are made and make that determination one way or the other. And the other basic concept that I wanted to bring up is one that I believe Your Honor was questioning a little bit. This is a lawsuit about an insurance contract, okay? To bring a lawsuit about an insurance contract, it has to be based on the insurance contract. It has to be based on the fact that there was a loss, that they're seeking indemnification, and that it has to be based on the terms of that contract. A claim for attorney's fees is not based on the contract. That's a statutory claim. The role of HICA that was explained by counsel is one to pay attorney's fees, to pay for the litigation. How is that an assignment? How does that give them standing in a litigation? Because it's a litigation based on an insurance contract, not based on something else. It's more like an assignment of a retainer agreement. It's not like an assignment of an insurance contract. Because again, remember, the right to the duty to pay for attorney's fees and then the possible recovery of statutory fees, that's statutory. It's not something that comes from this contract. So those are just some concepts that I want to start. And then also, Your Honor asked a few questions about the fact there's no transcript. The only thing we really do have here is a very extensive motion to dismiss. If you look at the motion to dismiss, all of these arguments, including the ones I'm making now, were included in that motion. And we do have the memorandum from the trial court that they issued right after the ruling, where they found that the plaintiff had no standing. So that was the basis of what the notes the court took from the hearing. And then we have, of course, the order. So there's been a lot of discussion about the Sigma funding case. And I believe counsel said that it appeared the trial court had ignored it. The trial court did not ignore the Sigma funding case. The trial court cites to the Sigma funding case. And if you look at the Sigma funding case, you can see that the facts there are very different. Again, the questions that were raised, the first paragraph of the Sigma funding case describes a factual situation that was included in that complaint that's completely different from this one. In particular, so the first paragraph there says, or one of the first paragraphs, in July of 2019, the insureds assigned $9,570 of benefits payable, rights, and causes of action under their policy to Sigma. In return, Sigma provided advanced funding for a portion of the insured's claim. Sigma then sought reimbursement from the insurer, which it denied. You can see that's very different than the facts that we have alleged in this complaint. In this complaint, Your Honor pointed to paragraph 10, and in those paragraphs, HICA sets forth that it's an alternative option for consumers by providing accountability, financial protection, and relief from onerous obligations, etc. That's a very different role. It's a very different factual situation that was involved in the two cases. And then more importantly, the statute was very different. So I think before I get into that, the first analysis that needs to be done and was requested of the trial court is, was there legal standing? Okay, legal standing is different than the standing for an assignment of benefits contract, right? So for legal standing, what you're looking at is whether the party has a sufficient interest at stake in the controversy, which will be affected by the outcome of the litigation. So to have standing, a party must demonstrate a direct and articulable interest in the controversy, which will be affected by the outcome. How is paying for attorney's fees, possibly even recovering statutory, but how is that qualify as standing? It doesn't fall into the definition of legal standing, which is the first step that needs to be looked at. Then if the court finds, okay, there's enough for legal standing, then the next step would be to look at, does it need to comply with the assignment of benefits statute? And again, as was brought up, the statute that was at issue in Sigma funding was the old version. That's very clear if you look at cited within that statute, within the case. So it's the old version. We all know that the legislature doesn't amend a statute to just add superfluous extra language. They did it for a reason. They added this language which expanded the definition. So if somehow the court found that there was standing, like legal standing, then the court looked further and would say, okay, does this fall within the assignment of benefits statute? And I think it clearly does if you look at the way the statute was amended based on the allegations in the complaint. Because they do put some allegations in there, not necessarily enough, I don't think, but they did put enough in there for the court to find that there was no standing.
So what portion or what was alleged in the complaint that you think makes their services, like services that are outlined in the statute.
So that's part of where, if you look at it, they don't allege that they did. So let me back up for a minute. That ain't not right. So the statute, remember, it says including but not limited to. And in addition, underneath it, it also has a separate subsection that excludes specific types of assignment agreements. And that's important, right? Because the statute says including but not limited to, except for these, all right? So it only has a few that it doesn't include. So what I think, if you were to get past the initial standing and look at this, it's a service that they're providing. They do talk about the damages to the property. So it's got to comply with the assignment of benefit statute if it is an assignment that gets past that first step. Because what else can it be? This is an insurance policy lawsuit, and it's dealing with recovery of indemnification to restore the property. So that's the basis of that's what you're asking for. And so if they're coming in and asking for that relief from the court, that brings them within the statute. What else are they asking for?
But they were just, in my mind, what you were telling us at the outset was they're just looking for the money, so to speak. Is that wrong or right?
Well, not necessarily, because if you look at the way they allege it, it's not even that they're just looking for the money. They're paying the attorney's fees. They don't even really say that they're getting reimbursed. They don't have that language in there.
So if it's just about attorney's fees, then I'll tell you where I'm going. I'll finally just say it. But if I look at, there's the canon of statutory construction, right? And I'm not going to be able to pull this right out of my mind, but if there's a specific list, right? A word is known by the company it keeps. Okay. So if there is a general phrase and then there's a specific phrase, now whether we reach the canons might be a question of its own at this point, but if there is a laundry list and there is something that doesn't look like the duck or quack like the duck, as the trial court put it, why isn't that necessarily excluded just by virtue of the laundry list that they gave us? So if the laundry list is only farm animals and you've given us a tiger, why do we think that that's included?
Well, I think in this case, the way that you would do it is similar to and I always get the name of this case wrong, so I'm going to actually spell it for you. The adjective, where the court noted that in that case, so it's spelled ADJEI versus First Community Insurance Company, 352 Southern 3rd 900. That was an assignment of benefits case where the children of the named insured, they received an assignment from their parents. And the court found in that case that that still qualified under the assignment of benefits statute because those children were going to bring this insurance claim in order to get the money to fix the house. So in this case, if they're seeking services to, including but not limited to the ones that are listed there for the property, if they have standing at all, because otherwise they don't have standing. So that's why I say you kind of have to reach that first issue first, right? And if the first issue is, okay, they have standing, then that means there's more to it than just the paying for because paying for the lawsuit doesn't give them standing under an insurance policy, because how is that assigned under a policy where it's not included? It's not a term of the policy. So then, I don't think they have standing at all. But if you get to the next step, then it has to be a service for the property because how else do they have standing? That's kind of a circular idea. Any other questions?
No, thank you.
Okay, I think that's all of it. Unless anyone has any more questions about any of the issues. Based on the record before the court, I think that the trial court made the correct ruling.
Actually, I did have,
Yes.
I think opposing counsel said that it wasn't raised below, but was the rule 1.130 issue on failure to attach the complaint the assignment to the complaint, was that brought up?
Yes, Your Honor, that is in the motion to dismiss. If you look at the motion to dismiss, it's very lengthy and it includes every argument, all the arguments I'm making here, all of the arguments that the court has raised. It did include that argument in the motion to dismiss.
So that was my recollection without digging it back out. So the court had that before it, and while it didn't specify in its order, it certainly was argued. I mean, in writing, unlike anything else that would have might have been in the transcript that we don't have.
Absolutely. And unfortunately, I was not the counsel that handled this. I didn't even get to do the briefing. I was handed this case very recently. So I wasn't there to give any insight, but unfortunately, we don't have a transcript. So all that we do have is the very, very extensive motion to dismiss. As I mentioned, the court memorandum where it said that it found that the plaintiff did not have standing, and then the court's order. And based on all of that, based on the Sigma funding case, and based on the standard for a motion to dismiss, it's my argument that the court properly ruled and that this matter should be affirmed on.
Thank you. Mr. Barr.
I'll go quick. Judge Stargell, they didn't raise it in the brief, so it's waived. They did raise it in their motion. The court didn't rule on it, and they haven't
I
raised
was
it.
only asking, you said it wasn't raised below. So it wasn't-
Actually, if I might have said that, what I meant to say was it wasn't ruled on. And they didn't raise it in the brief. I
Mr.
would-
Barr, if the statute specifically lists exceptions and you're stating that your client is not included, notwithstanding the language, including but not limited to, then when we look at the exceptions portion of the statute, why are you not asking us to read something into those exceptions that is not there?
It's a very good question. I was going to bring this up when I was going through kind of the history of the statute, but when the 2019 version came out, and it was very specific, like only these 6 types of services does the statute apply to, those exceptions were still there. Okay, they weren't added when the legislature amended it in 2022. So we can only read that to say that those don't apply if they also would have fit the agreement other than what they're titled. So it's not saying that, well, we're not going to even look at these under 6277152. What it's saying is if they otherwise apply, the statute otherwise applies, we're not going to apply the statute to these 3 types of assignment agreements. So the statute has to apply first. In our case, the statute doesn't apply at all because they're not services to the property. So we have to look at the amount of time. We have to look at the statute as a whole. Appreciate your time. We ask the court to reverse. Thank you.
Thank you. Thank you both for your presentation.